Welcome everybody. I'm Matt Dana of Dana Whiting Law, and I have my partner Trevor Whiting. Good morning, Trevor.
Hey Matt, good morning.
Are you ready to talk a little tax law?
I love talking about tax law.
We know that it's going to be a good subject if Trevor starts to drool all over the table, and we might get him to say a code section or regulation here.
It might happen, the drool, the code sections, it all might happen.
Well, today, Trevor, we're going to talk about a topic that I know that's high up there for both of us. And I'll give Trevor credit. He's been with me for over 15 years, and we've developed 3 words that embodies all of high net worth estate planning, right, Trevor?
That's right.
What are the magical 3 words?
We've got squeeze, freeze, and please.
Wow.
Yeah.
So those,
and they all rhyme.
all we have to do is teach our client those 3 words, and literally they will know all the tools that are available in high net worth estate planning.
And you listen to this video, you'll know what squeeze, freeze, please means, and you'll remember it, and you know our clients remember it, and it's a easy
Trevor,
tool.
I have to say that I think that's really the advantage of our law firm, is because a lot of attorneys want to get puffy and talk about code section and regulations, where we just want to talk about concepts they understand, right. Make these simple words. I think we have to lay some foundation of why we feel that we're experts in this field. I'll talk about myself first, and I'll let you talk about your credentials. But first of all, I've been doing this for over 40 years. Second of all, I'm a CPA as well as an attorney. And third of all, I have a master's degree in NYU, an LLM in taxation. Not to mention, I'm also a charter life underwriter in life insurance and a few other things. But I've been studying tax law for 40 years. Now, Trevor, I'll let you brag on yourself for a minute.
Yeah, I've been, since law school, or before law school, I did an MBA and then went to law school and then did the NYU LLM as well, and studied taxation and estate tax and gift tax and transfer tax, all the taxes we like to talk about. And then I've been doing this with you, partnered for 15 years or so, and with a high focus on these concepts and teaching them to clients, teaching them to other professionals and the public and things like that. So,
well, and I'll also say, Trevor, you have just a phenomenal ability to read a court case or a code section or regulation and it sticks. Yeah. And I think that's what's really impressive.
Thank
you. When we're really trying to dive into the detail, in some of these concepts, I think our listeners need to understand tax law. When you get up to this high level, it's not necessarily black and white. We have to take sometimes a regulation over here or a court case over here and merge them together to get a result that maybe hasn't been tested. And as we go throughout this video, I think we should try to talk about things that have been tested, that are black and white, and then maybe talk about things where you're getting out there. I hate to use the word shades of gray because it sounds, devious, but there are things out there that aren't code section and regulation,
or that just haven't been, like you say, tested in the tax court or in some of the other courts, where we know for sure that when you do it a certain way that it works, or you do it a certain way it doesn't work.
Yeah, and I think the way the code section works is, we would actually have liability if we recommended a strategy where there wasn't a reasonable basis for it.
That's right.
And so I would say, first of all, we're never going to say anything that's illegal, and we're never going to recommend anything that doesn't have, in our opinions, a reasonable basis. I did a seminar last week up in Sedona, and one of the questions was basically I was talking about estate tax reduction by gifting assets, and talking about the limits of what you could give away and what you have to report. And one of the questions was how's the IRS going to know? Basically asking me, well, if they're not going to know, we're not going to tell them. But that's not our business, is it, Trevor?
That's not. We do the strategies that we believe have a reasonable basis, and then most of those are reported to the IRS. We report them on a gift tax return or some type of return, and so the IRS is going to know about it, and we're going to lay out what our reasonable basis is for taking that position.
Okay, thanks. Trevor, as we talk about the word squeeze, I'm proud to say you and I, we developed these 3 words.
Right.
And now I'm writing articles on it. And when you talk about a squeeze, I'm going to lay out kind of a broad picture, and then I'm going to have you kind of jump into a little bit more detail. But when I think about a squeeze, the way I would summarize it is, Right now, everybody's got a federal exemption that's just south of 14 million. Trevor, what is it, 13?
13,610,000.
See, I told you you'd know that. 13,610,000. That's how much we can give away with no tax consequence, right? And it's a free gift. It's a free transfer. But the squeeze basically is trying to squeeze 18, 19 million into a 13 million. It's kind of like getting down to that girdle. Trevor, do you wear a girdle anymore? Did you give that up?
Not anymore. Okay. Yeah, I've given that up.
All right, so we try to squeeze that 18, 19 into that girdle, and then we're gonna make a gift somewhere. So the elements I'm going to get into was, when you think about this, the question is, first of all, when you talk about gifting, how much can I give? Well, that's the exemption. And then with discounts and valuation, things we're going to get into a minute, you're going to get 18 and 20 million into that exemption. So how much can I gift? Who can I give it to? And we're going to talk a lot about giving. We don't like to give to people. We like to give to trusts for different reasons. And you know, those are the, and then, you know, what kind of reporting requirements. But let's talk about, first of all, what's particularly important right now about this, you know, $13 million exemption. What's in the news, and why is this a very important topic right now?
Yeah, the big issue is that this the exemption is scheduled to be cut in half in 2026. So there's an index for inflation, and so every year since 2011, that exemption has crept up a little bit. In 2016, President Trump passed his tax reform and he doubled the exemption, and so that's why we have this historically high $13,610,000 exemption. And we'll get another little bump for inflation next year in 2025, but in 2026 it's scheduled to be cut in half.
Yeah.
And so, you know, the IRS has said, though, that if you use your exemption right now while it's high, then you'll be grandfathered in and you'll lock it in. And so we tell clients that you can use your exemption either at death or during life through these gifts. And so that's where we talk to them about making a gift to a trust like you were talking about.
Yeah, and so when we talk about this, you know, using that exemption, the way you use it is you have to make an irrevocable transfer somewhere. And we'll get in a minute where we're going to make the transfer to, what type of trust we're going to make the transfer to. But what I want to get into is part of this squeeze and getting down into that girdle. I referred to valuation discounts, and elaborate a little bit on how do we get 18, 19 million and convince the IRS it's worth 13 million?
Yeah.
Where's the squeeze coming in?
The squeeze comes in, you know, our one of our best tools, and Matt, I know you wrote an article, you know, years ago about the family limited partnership being the GOAT of estate planning, right? The greatest of all time. And that the family limited partnership, or a lot of times we use an LLC these days, but that entity is what gives us that squeeze. And what I tell clients is, all we're doing is we're trying to say on paper that the client has less than they actually have. Yeah. Right? We're not actually taking assets away from a client or anything like that. And so we structure that partnership with voting and non-voting interests, or a general and limited partners. And when we make an irrevocable transfer of a limited partnership interest or a non-voting interest, then we go out and we actually hire an appraiser to tell us what types of discounts ought to be applied to the value of that non-voting interest. And when we get the report back from that appraiser, they come back and they say, well, one, there's a discount for lack of control because they don't have a vote and they can't direct when distributions are made or anything like that. And two, there's a discount for lack of marketability. That partnership, it's created within the family. You know, we don't have outside investors. It's not listed on the stock market, so there's not a market where you can go out and just sell your interest in that partnership. And so there's a lack of marketability, and the appraiser will say, well, because you can't just go out on the street and sell it to somebody else very easily, then there's going to be a discount. If I was in a partnership and Matt, I was selling you an interest, and the interest you were going to buy says that you can't turn around and sell it without consent of some other parties, and you don't have control and things like that, you're not going to pay me full value for that. You're going to say, well, Trevor, I might pay you, 50 cents on the dollar or something like that. But so those discounts are what gives us the squeeze and make that girdle. And
we got a new name now, girdle.
Yeah, we'll start using the girdle, but we can get that $18-20 million down into what looks like on paper something only worth $13 million that we can gift away.
Talking about the squeeze, that in the 90s I had a case that really showed me how valuable family limited partners were. And back in the 90s, it wasn't really a well thought out idea that you could get these discounts. But as it started to emerge that you could claim these discounts for lack of control and lack of marketability, it was thought that you could only do that with things like real estate that really do look like they're illiquid and unmarketable. And so in the 90s, it was thought that you couldn't put stock in a partnership and claim discounts on stock. And I had a case where I had a client that had $1 million worth of Abbott Laboratory stock. And when the stock, I remember it selling for $50 a share. When we started working with this client, it was worth $50 million. By the time the client died, the stock was selling at $90 a share and he was worth $90 million. But we created the partnership and put the stock in there, and when the client did this squeeze technique like you're talking about, and he created these trusts for the kids, and he transferred a non-voting limited partnership interest into these trusts. The client died a few years after we'd made these transfers and we made these gifts, and we filed the gift tax return and we claimed a 33% discount on that. And the IRS came in, obviously audited, because you're talking about a 33% discount now in a partnership that's worth $100 million. We're claiming a $30 million discount on a 40% tax. We're talking about saving that client $12 million. And of course they came in with guns blazing, and as we went through the audit and fought the audit and dealt with the audit, we ended up settling that case for a 30% discount. It was just a very thin shaving. And this was back in the 90s. And that's what prompted me to write the article, The Family Limited Partnership, in my mind, is the greatest estate planning tool of all time. To be able to make 30% of value disappear just like that. And so that's critical part of the squeeze, is this girdle we're talking about. And then just quickly, Trevor, who do we like to make that gift and that transfer to, and then we'll finish up the squeeze?
Yeah, the gifting, we always like to gift into irrevocable trusts. And there's a lot of different types of irrevocable trusts that we'll use, but usually it's some sort of trust that we create, maybe for a spouse, maybe for the children and grandchildren. But we like to give it into an irrevocable trust because that type of trust gives benefits related to asset protection and exemption from estate taxes for future generations.
But it's a multi-generational trust.
It's multi-generational, and so the assets are gifted in, and then when the beneficiaries pass away, it rolls on to the next generation, and so it's multi-generational, a kind of a dynasty type trust that some clients may have heard of, and so we always want to make a gift into those types of trust, and so that we get those benefits as that wealth is transferred down.
Yeah, and Trevor, one of the other articles I'm proud of, I wrote an article called simply Red Box, Green Box. And that article, Green Box, talks about the different types of trust that we can make this transfer into. And so I think this is a great conversation, and I appreciate your time today.
Yeah, thanks, Matt.